Yes, go ahead, Mr. Crawford.
Good morning, Judge Kelly, Judge LaRose, and Judge Atkinson. My name is Andrew Crawford. I'm here on behalf of the appellant in this particular case, Brian Stanley. This case comes to this court from Pinellas County and for the Sixth Judicial Circuit. Judge Kelly had respectfully asked to reserve 5 minutes for rebuttal.
All right, sir.
Your Honors, this case comes to the court after an evidentiary hearing on a violation of probation. There were three bases that the court alleged, that the probation alleged, and that were proven as found by the trial court. The first issue in this case is whether or not the state proved the violations of probation by that they were willful and substantial, and whether they proved it by the greater weight of the evidence. The three bases for the violation of probation were: number one, failure to complete the DUI school, multi-offender DUI school; number two, failure to complete 100 community service hours; and number three, a failure to report. There has been a long line of cases from this court as well as other district courts of appeal that have specifically held that if there is time remaining to complete outstanding conditions of probation, as well as that the initial order of probation doesn't contain hours per month or a specific time to complete those those conditions of probation, then it's very difficult for a trial court to hold that a violation of probation is willful and substantial.
Mr. Crawford.
Yes, sir.
What is your test? It can't possibly be that I have to wait until the last day.
It's not, Judge LaRose. However, this particular court has said that to avoid this problem, trial courts should impose some type of hourly or some type of date for this to be completed. Now, in this particular case, the probation officer imposed an arbitrary 90-day time limit when this must be done. That was not contained anywhere in the order of probation. Furthermore, the case law is very clear that a probation officer cannot impose, or a probation supervisor cannot impose, a time limit that's not contained within the order of probation. They cannot create a new condition of probation absent a court order. They don't have jurisdiction to do that, and that's what happened in this particular case, as cited in the argument.
Is it unreasonable to put a probationer on notice that, hey, fellow, you're coming up to the end. You have these outstanding obligations. Let's get them wrapped up by a certain date so everything will be clear.
I don't think there's any problem with a probation officer saying that. There's no problem with the probation officer saying that. The problem is a probation officer says, you've got to complete these outstanding conditions of probation. If you don't do them by a particular date, 90 days prior to the term date, I'm going to violate you and find a willful and substantial violation. That's not the law, and that should not be the law in the state of Florida. Obviously, a probation officer can advise somebody of time that they have to complete the probationary terms, but they can't impose an arbitrary 90-day rule, or if you don't complete it by such and such date, then you're going to be violated and taken to court for an evidentiary hearing, which is precisely what happened in this case.
Does your client's situation warrant a departure from the rule you advocate? If we accept it as a rule, this is not a fellow who's on his first probationary 2-year term. He's had these conditions outstanding for several years and apparently is unwilling or unable to comply.
I understand the court's situation, and I understand your Honor's point. However, in this particular case, there was evidence that Mr. Stanley suffered severe injuries as a result of an automobile collision in 2016. Yes, his probation had been extended twice for failure to complete certain terms. As it relates to the DUI school, I think it's critical to note that it's not he must complete it. The order of probation says he must enroll in it, and he still has sufficient time in order for which to do that. As it relates to the community service hours, again, he had an auto accident. He testified as to the injuries that he sustained, as well as mentioned the serious injuries he suffered, which could have prevented him from completing these community service hours. Furthermore, he still had time to do them. Therefore, he should not have been violated for them. But yes.
Mr. Crawford, I have a question.
Yes,
On the
ma'am.
occasions where he was violated and his probation was extended, is it permissible for the court on those occasions to insert a date into the order, to amend the order to put in a date certain by which he has to complete it? Or would that be some type of impermissible alteration of the original probation order?
No, I think that the court has jurisdiction in order to do that. The statute specifically says that when a probationer is brought before a court on a violation of probation, the court can revoke, modify, or extend the term of probation. If a court can
So-
modify the terms of
So at
probation.
any time, the court could have put in a date by which
Correct.
he had to complete these tasks?
Absolutely, a court could have. The court could have, the probation officer could not.
I understand, but so the court could have. So
They
there,
did.
so the
court
fact that
absolutely-
he kept coming in and he wasn't making the type of progress that the probation officer and the court thought he should be, there was a remedy. Is that right?
There is. The court could specifically have modified the terms of probation and given him a monthly hours, or could have said you must complete it by this date, otherwise you'll be in violation. That absolutely could have happened on the first two violations of probation. Additionally, the DUI, the multi-offender DUI school is a very expensive course. It's not something that's just $50. It's at least $600, $700. And Mr. Stanley presented unrebutted testimony that he could not afford to pay for that course.
And am I correct that the court made a finding that he could not pay for it?
That's absolutely right. The court specifically found, well, the court made a finding that he did not have the ability to pay the fines and court costs, which were approximately $1,300.
So
However,
you're inferring from that he also could not afford to pay the DUI?
correct.
Okay,
Correct.
but there wasn't a specific finding with respect to the DUI school?
Not to my recollection, Your Honor, no.
Okay,
The court just found Mr. Stanley to be in willful and substantial violation for failing to complete it. Again, the original order of probation says he must enroll in it.
Enroll.
Correct. So there was not a specific finding as it relates to that. The third violation of the probation was the failure to report. The original order of probation, Section 1 specifically says that Mr. Stanley must report as directed to the probation officer. Now, there is evidence in the record that Mr. Stanley reported to probation in October of 2017. There's a dispute of what was actually said during that probationary meeting in 2017. However, the probation officer specifically said that she said that he was going to be violated if he did not complete the outstanding terms. Mr. Stanley said she told him that his probation would be violated. And as a result, according to his testimony, based on the two previous violations of probation, he was waiting for the warrant. He didn't think he needed to appear because, the warrant was going to be issued.
But if we have to credit the probation officer's testimony, as did the judge, trial court, and presuming that her version was correct, she said, well, I'm going to violate you if you don't get everything done. And it sounds like the trial court might have been correct in his or her, I forgot at this point, his or her estimation that the defendant just threw up his hands, said, well, why should I try to comply with the clear direction of the probation officer to appear if I just, I'm probably not going to get that done. I'm going to go get violated anyway.
Well, the law is equally clear that a failure to report as a result of a miscommunication or misunderstanding does not rise to the level of.
But the trial court didn't think it was a misunderstanding. The trial court seems to have credited the probation officer's testimony that the probationer heard what the probation officer told him.
That is what the trial court ruled. Nevertheless, this court is still entrusted with determining whether or not the probation was willfully and substantially violated. The argument that I assert in the brief, and then I'll raise again on at this oral argument, is that he cannot be found in willful and substantial violation if there was a miscommunication or a misunderstanding with regard to the date to report. On this particular case, he specifically testified that he didn't leave the jurisdiction. He actually called the Pinellas County Sheriff's Office to see if there was a warrant issued, and he thought he did not need to report based on a pending violation, which he testified.
So let's walk through that. So he thought he didn't need to report.
Correct.
So he was told. You would say there seems to be different layers of what is essentially a factual argument. One is if we presume that he did hear a clear directive to appear on a certain day, your argument is that he justifiably thought that need not be adhered to because of the probation officer's professed intention to violate him?
My argument, Your Honor, is that if a probationer is confused about whether or not he or she needs to report, and the failure to report is a result of a miscommunication or a confusion, that's insufficient under the case law to establish a willful and substantial violation of probation, which I respectfully submit is what we have here.
But I wanted you to walk through the details. This is your chance to make your case.
Yes, sir.
It's a factual argument. In other words, the facts support confusion, and here's why a reasonable probationer would be confused. Having heard a clear direction to report on a specific date, also having heard the professed intention of the probation officer that, according to, let's just presume for the sake of discussion, that the trial court had credited the defendant's testimony, and even if that is so, then the defendant said, well, I also heard a professed intention for her to violate me. And how could that lead to a reasonable probationer to the conclusion that I can ignore the directive to appear at a date certain?
A reasonable probationer in Mr. Stanley's circumstances, who had been twice violated before and had not had to report and been picked up on a warrant, would have assumed that they were going to be arrested on the violation of probation warrant. Therefore,
so once the day in question came when he was to appear and he had not been apprehended by law enforcement officers, wasn't there a choice he had to make? Hey, you know what? Maybe I should show up. I haven't been arrested yet.
He did call the Pinellas County Sheriff's Office to see if there had been a warrant. He did not flee the jurisdiction, and I believe there was testimony in the record where she'd actually done a home inspection. I think it was reasonable of him to assume that because she didn't issue the warrant or try to violate him until December the 28th of 2017, not November of 2017.
And the home visit was in November, is that right?
That's my understanding, Your Honor. So it would be reasonable for him to assume that based on the home visit, as well as based on the warrant not being issued until December of 28 of 2017.
Mr. Crawford, you're nearing the end of your initial time, and I just want to sneak in a question real quick about your third issue.
Yes, ma'am.
The way I read your argument is you're not quite certain about counting the days. Nobody is quite certain about counting the days.
Your Honor, the third argument, Mr. Stanley was originally placed on probation concurrently for 2 third-degree felonies with obviously the maximum possible penalty of 5 years in prison. I understand that probation tolls. This court issued a decision, which I believe I cited within the third issue, basically that when a probationer has been placed on probation and has gotten jail terms, that must be credited toward any subsequent violation of probation, which could put him outside the statute of limitations for this offense. Obviously a jurisdictional issue. In an abundance of caution, I raise that issue as a third issue and respectfully submit that he may be outside the 5 years. So it's a maybe,
but you're not sure, is how I read your argument. And it sounds like that's what you're confirming.
That's what I'm confirming, Your Honor. I want to raise it in an abundance of caution because there's a possibility he may be outside that term. That's why I cited that particular argument. and raise that particular court case that this court issued in abundance of caution.
Okay, thank you. And you've got about 30 seconds left before you're at 15 minutes.
I respectfully reserve the balance of my time for
Okay.
rebuttal.
Okay, thank you. Mr. Campbell?
Yes, good morning, Your Honors. David Campbell, representing the state of Florida. I think one of the big issues would be whether or not for issue one, the three failure to report, the DUI school and the community service hours. As I mentioned in the brief, I don't believe that that is necessary for them to put in a definite date to complete. I think as the cases outlined, the fact that a defendant is put on probation gets that benefit if they have to take a class such as a DUI, sex offender course, whatever. They should know by the fact that they're being put on there that they need to take it immediately.
At the time that the probation affidavit was filed, though, how many months were left in the probationary term?
I believe he had about 2 months left.
2 months.
Out of the 5 years.
And
Yes.
and he thought he had 87.5, but the court didn't credit that because that's what he had to do just to live where he lived. So let's say he had all 100 left, and there's how many work weeks? I mean, if this were to be a test case to question what seems to be a pretty formulaic rule, which is that if you have time left, you can't be violated when there was no due date in the probation order. How is this a good test case for that when he had, would you say 2 months to put in 100 hours?
I believe he had about 2 months left, yes.
I mean, that's a tight fit if someone has it trying to hold down a job, but it's far from impossible, isn't it?
Well, as I mentioned, if it's, I'm sorry, go ahead.
No, answer the question. I'm sorry, I interrupted.
Well, yes, it may be theoretically possible. However, the court has to be able to, maintain control over the probationers. And this wasn't even on his first time. He had been violated twice before. Well,
Mr. Campbell, isn't the solution to this problem to put a date in the probation order to begin with, or certainly when he's violated? I mean, you posit this hypothetical of, he could just wait till the last day and then he's out and he's never complied. Well, how is that his problem if the court doesn't put in a date? The state can certainly ask for it.
Well, yes, I agree. It would be nice if they would put in a date, but the Florida Supreme Court has found actually that's not necessary. The probationer knows that they should immediately start to fulfill their requirements. And in this case, it is an abuse of discretion standard. The trial court and the probation officer had given him plenty of chances. There's no guarantee, just like with the sex offender case, I believe that was Adams, that just because, at the very end, he suddenly shows a willingness, there's no guarantee you're going to get another chance. Because you're put on probation that you need to go take it. And he was violated because he was willfully not trying to comply. It wasn't that he couldn't or he couldn't afford it or he was injured, but he wasn't even trying to get help. He wasn't bringing that, according to the probation officer. He was willfully, like underemployed or willfully not trying to get assistance. It was not just that he couldn't afford it. So the court can take a look at that and see that a probationer is genuinely not trying, not making a bona fide effort. And if they're not making a bona fide effort, then they can be violated.
So, Mr. Campbell, you're forcing us to draw some pretty arbitrary lines. Judge Atkinson notes that, it's conceivable he could have done all this in 2 months. Suppose the probation officer does think the fellow is dragging his feet, but he has 6 months, he has 7 months. Are you telling me that because the probation officer concludes that this person is just dragging his feet, that's a basis to VOP him?
Well, there's several layers. There's the probation officer who then, doesn't actually, find him in violation and send him to prison. She sees that he's not working out. She then files a violation. The court then has to determine, the court takes a look at it. That's another safeguard level there.
Well, would you agree that a trial court could VOP someone if he or she had 6 or 7 months left?
Yes, according to Lawson and Adams, yes. They have that discretion.
But are those different scenarios? Correct me if I'm wrong, but the one of them, I'm going off the top of my head, it wasn't a number of hours. It was failure to complete a program. But correct me if I'm wrong. Can you walk me through those two cases you're relying on? My understanding is some of the cases you were relying on were scenarios that were, square peg in a round hole, which is, what you went into the program, you failed out, and that we could say you willfully failed because you didn't try hard enough to complete it. Well, what's a case in which there was a number of hours and there was time left and a violation of probation was affirmed?
I don't believe I have one that was a number of hours. I believe those were the two on the courses, the drug course and the sex offender course. And in those cases, well, this defendant was given, he was put back on probation several times. It wasn't an abuse of discretion. Everybody was bending over backwards for him. The trial court even said for the DUI class, if you had even enrolled, done anything, I wouldn't violate for that. Now, it's not just the lack of the hours. Even by his own admission, he didn't do the extra 13 he needed to do. He didn't provide any documentation for it. It wasn't just that he couldn't do it, was injured. They weren't being unreasonable. When you listen to what the defendant was saying, he was basically misleading the court. I believe there was the mischievous manipulation was one of the lines in the cases. I believe that was from Adams. If you just make this arbitrary, if there's time left, yes, he will for sure be able to take the course again. So in this case, there wasn't an abuse of discretion. This wasn't an illustration of where people don't particularly like this defendant. They were bending over backwards for him. So it's what you're talking about. I don't believe that's the scenario here at all. He had plenty of time if he really did those extra 87. However, the court didn't find him credible at all. Quite frankly, the court thought he was lying. As the court said, we know he knows how to document these hours, but he didn't. So they weren't just arbitrarily, yeah, you've got some time left, but we don't think you were compliant enough. We're just going to violate you. This was at the end of 5 years when he didn't do almost anything. His testimony, he was talking about, he was actually reporting income. And also now he suddenly can complete the course. He suddenly can enroll. Now that he's in jail, he can get some help for it, whereas he couldn't before. I mean,
I agree that supports the trial court's conclusion that he may not have been on the up and up and all the excuses he was providing. But let's say that we find that violation for that condition was inappropriate. Can you talk about the failure to appear? I mean, what am I missing in my discussion with opposing counsel about whether there was actual grounds to suggest that confusion was justification for failing to appear?
Well, he was given a card with the actual date of November 6th at the October meeting. Probation officer gave him a card with the next date.
But counsel said there was confusion arose when he thought, well, I'm just going to be arrested for violating probation anyway. Well, why doesn't that undermine the willfulness? Is there an argument to be made that he thought, well, I was told to appear, but obviously that's no longer an imperative because it's over. I'm going to get violated and go to jail. Am I missing something? Am I misunderstanding?
I would think accepting that argument would be, I mean, talk about a slippery slope that a probationer can just decide not to appear if he thinks, oh, well, it's over, I'm going to be arrested or something. That seems like it would be, the probationer doesn't have the choice not to appear unless there's, for some reason, he can't make it. The car breaks down, et cetera, and then he needs to try to get there the next day. For him just to arbitrarily on his own, no, it's not going to work anymore. I'm just not going to show up. The probationary system needs them to follow the instructions. That's the only way it can work. He can't just come up with his own excuse of, well, it's not going to be any good anymore. She's going to violate me, which once again, the judge found not credible. So he would be making up basically a falsehood and then using that as an excuse to willfully not appear. And once again, that goes to the it's an abuse of discretion standard. The trial court was there listening to the defendant, and the trial court found he wasn't credible. And a actual willful, flat out violation, I'm not going to show up this day even though I've been given a card, that is grounds to revoke his probation. So no, I don't think you can just let a defendant come up with that excuse of, well, I don't think it was necessary anymore. It's always necessary. He knows he's supposed to report every day or every month. And he had been doing this now for 5 years. He knew the rules of the game at this point. I think it is important to realize that this was 5 years in. This wasn't any like arbitrary decision just to violate him because of what the probation officer said. He was at this point willfully not complying, working for ways, finding ways not to comply, and continuing to come up with excuses. And I think the judge in this situation has to be given, that discretion to violate him in this case. Were there any other questions?
Well, we could talk about the timeline. What had jurisdiction been lost because of, or would the tolling provision extended to the point where jurisdiction?
No, I don't remember the math I did, but I went over it, and no, I found that I did the math, used the dates, and no, jurisdiction had not been lost. Due to the tolling, he was still within the 5 years. So no, I think if you go through the math that I laid out in the answer to the third question, it's no, they still have jurisdiction over him. All right, were there any other questions here?
No.
I don't think issue 2 was addressed, so I won't address that then.
All right, Mr. Campbell, thank you.
Thank you.
Mr. Crawford?
Yes, Your Honor, just to respond to some of the things that Mr. Campbell said. This court and many other courts throughout the state of Florida are frequently confronted with issues such as this, where there's still time to complete the outstanding conditions of probation. The simplest thing in the world, which this court has been mentioning since 2006 in its opinions, is for there to be a due date that's actually put in the order of probation or some type of monthly hours. If a probationer has not completed those, a violation of probation has been filed, and there's a modification of probation, the easiest fix for that, which both Judge Kelly and Judge LaRose have touched on, is to modify the probation and include a specific date or time or number of hours that must be completed per month. Mr. Campbell talked about a slippery slope in terms and cited to both Lawson and Adams. Trial courts are not, as the state is arguing, given unfettered discretion to violate a probationer, especially when there's still time to complete the remaining terms of probation. To advocate for such a rule or a bright line rule gives trial judges too much discretion and would take away from this court's appellate jurisdiction to ensure that due process was given to a probationer, as well as that the probation violation was proven by the greater weight of the evidence and the violation was willful and substantial. To advocate for such a per se rule under Lawson, as well as Adams, is not in line with the Florida Supreme Court's reasoning. I'd respectfully ask the court to reverse and remand and find that Mr. Stanley did not violate the conditions of his probation. Unless the court has any further questions, I'd respectfully rely on my previous arguments and the arguments contained within the initial and reply brief that I made.
Okay. Thank you. Thank you both. Our next case, State Farm Mutual Automobile Insurance